Hi, welcome to Constitutional Chats, hosted by me, Janine Turner,
and Cathy Gillespie,
with students
Dakare, Chatman,
and me, Tova, Kaplan.
Join us as we discuss hot topic issues with constitutional experts. It's sponsored by Constituting America. My name is Janine Turner. I'm the founder and co-president of Constituting America. We've been in existence since 2010. I'm also an actress, and you can visit JanineTurner.com if you want to check any of that out. And the co-president of Constituting America is Cathy Gillespie. And Cathy Gillespie was a chief of staff on the Hill for decades, and she is now one of the few citizens, 16 private citizens. I think she's had a promotion, but I'll let her tell you that. On the U.S. Semi-Quincentennial Commission, helping organize the celebration of our country's 250th birthday in 2026. But she is just also, it takes two wings to fly with a bird, like an eagle, two wings. And so without Cathy, I'd be flapping around and on the ground, just hoping to get off the ground. And we like to say that it's our sponsors who are the wind beneath our wings, who bring this, helps Constituting America take flight. So with that, I will introduce Cathy Gillespie.
Well, thank you, Janine. And it is just a joy working with you every day. And we would definitely be off the ground without me, I can guarantee you, but we would not be off the ground without our sponsors. So we want to thank our sponsors for everything that you do to make these programs possible. And we especially want to thank today's sponsor, Robert and Nancy Zimmerman. And we first met the Zimmermans in, I think, 2016, when we were doing one of our founding father forums in Houston, Texas. And we were fortunate enough to have the Zimmermans come and attend that. And they loved what we were doing. And since that time, they've become very important supporters of Constituting America and advisors to us. They always have great advice for us. And Mr. and Mrs. Zimmerman, we thank you for making today's program possible. So I will turn it back over to you, Janine.
Great. Thanks, Cathy. And yes, we thank the Zimmermans so very much for the wind beneath our wings today, helping so many people learn how to use the United States Constitution for their benefit. That's what it's for. All right. I'm going to introduce the other great panelists we have on our panel at Constitutional Chats. Tova Love Kaplan. Tova Love Kaplan is our Constituting America National Youth Director, and she runs it like a CEO of a top 100 company. She's just simply brilliant. She is a junior in high school and lives in Illinois. She currently serves, as I said, as the National Youth Director, but she runs the council as well. And she's also running our book club now, both for adults and students. Many other things. She's created an app. I could go on and on. Anyway, she's a 3-time winner of our We the Future contest. Please check out the contest. In the entrepreneurial, where she created a marketing plan in 8th grade. PSA, she won for PSA, a short, of course, 60-second commercial, Know Your Rights, Read the Constitution, and STEM, where she created an app, as I already said. She's passionate about educating and empowering young people to use their constitutional rights. And Tova also is very interested in international governments, foreign governments, international relations. So Tova's going to be anything she wants to be, whether it's the CEO of a company or the President of the United States or Secretary of State. Welcome, Tova Love Kaplan.
Thank you so much, Janine. I'm, as always, so excited to be here. Thank you, everyone, for tuning in. And this is a really important topic, so I can't wait to get into it.
Great. Thanks. Thanks so much, Tova. Now, Dakare Chatman. If you look very closely at Dakare Chatman, when I quit talking and the Zoom goes to Dakare Chatman, you'll see behind him is the billboard. He's the face of Constituting America. The Constitution, it's an American thing, so know it. Those are his words from his PSA, and so his marketing plan, so to speak, is all over the country on billboards. But Dakare Chatman is multi-talented. But let's start with Constituting America. He is our student ambassador, and he is 18 years old and is currently a senior full-time college student in South Carolina. He's won Constituting America's We the Future contest twice, both for PSA, which I just talked about, and also for a short film, Man on the Street. All these are available to watch and see at constitutingamerica.org. He's actively involved in our National Youth Advisory Board. He's also actively involved in the book study and all the other things that we do. But he's also, look at this, he's a senior in college. He's 18 years old. He does so many things. He has so much energy, as does Tova. Cathy and I had that kind of energy when we launched in 2010. But he's an actor. You most recently seen in HBO's Righteous Gemstones and now in Netflix's Outer Banks, where he's always on the set. Dakare wishes to be an actor, but also a politician, but says you must be an actor to be a politician. Welcome, Dakare Chatman.
Hello, everyone, and thank you to the Zimmermans for sponsoring today. And yes, my billboard is there, so you can see that if you'd like. It's beautiful. Cathy, thanks for setting that up. Y'all are pretty great. And I just hope you guys enjoy today and learn a lot.
Great. And I forgot to say that you're going to see Tova as president, but you'll also see Dakare as president if he wants to be. But most especially, he'll have an Emmy and a Tony and an Academy Award in his hands. And I just hope that they both thank me from the podium. I'm expecting it, Tova and Dakare. All right. Jeanette Cranack is our director of communications. So if you would like to book a speech, operations, sorry. Lisa, are you director of media? Who's the director of communications? Oh, that's Lisa. Okay. Director of operations. She's been with us since almost 2010 as well, Jeanette Cranack. And if you would like to book a speech into your classroom or civic organization, I can be right there via Zoom, sometimes in person. And Jeanette Cranack is the woman to know. Jeanette, take it away.
Hi, thank you so much. I'm so excited to hear we have 17% teachers today. So that means 17% of our audience should send me an email this afternoon so that we can talk about bringing a private, either Constitution chat or a civil civic conversation to your students. We're scheduling for November now, and I know that you want to have more time with me and Janine, so give me an email, give me a call, all the information's there, and we'll be in touch.
That's right. Jeanette and I primarily give the speeches, though Cathy has done it too, and Dakare and Tova could do it, with by memory, by rote. All right, thank you, Jeanette. Gracious, wonderful, brilliant Jeanette. All right, now Lisa Williams, Director of Communications. None of this would be happening without Lisa Williams. She puts it all together. We have our Z generation and our millennial. And then whatever we are, I think we're technically baby boomers, which I find really hard to believe and I kind of deny. We're right on the cusp, 1962. I think it ends at 62. Welcome, Lisa. Thank you for all the brilliant work you do and all the editing. And once again, she's going to go into film work and be an editor. I expect to see you with an Academy Award in your hands as well. Welcome, Lisa.
Well, thank you. Aiming big, I guess, today.
Of
Appreciate it. If you want to see this or any of our other podcasts that we've done in the past, this is, if you guys can believe it, episode 44 of this podcast. Then you can see the full archive on our website, as well as if you search Constitutional Chats on any podcast platform, Spotify, Apple Podcasts, they're all on YouTube. So you can find them anywhere you normally find a podcast. And we're excited to be here today.
Thank you, Lisa, for bringing all that to life. So if you missed today, if you missed one of our Tuesdays, we can catch it later, which is always so handy. All right, our special expert today, as once again, we're doing the Bill of Rights all the way up until December 15th. So today we are continuing the First Amendment because there's so many amazing things in it. So it's the First Amendment Part 3. Next week will be the Second Amendment. And we're going to focus, as I said, on petitioning because that's where I believe you start with everything that's in the First Amendment. You go from petitioning, then you use your speech, then you use the press, then you plan your assembly, and then you take it to your representative. And that's how government works, because it's not just how the government works, it's how we can work the government, because it's from the people up. All right, special guest. Wait till you hear everything she's done. She's just amazing. Erin Hawley. And she is a senior legal fellow at the Independent Women's Law Center, a project of Independent Women's Forum. She previously served as an associate professor of law at the University of Missouri, where she taught constitutional litigation, federal income tax, tax policy, and agricultural law. Prior to joining the law school, Erin practiced appellate law at King and Spalding and at Kirkland Ellis, both in Washington, D.C. She also worked at the Department of Justice as counsel to Attorney General Michael Mukasey. Erin is a former clerk to Chief Justice John G. Roberts Jr. of the Supreme Court of the United States and Judge Harvey Wilkinson III of the U.S. Court of Appeals for the Fourth Circuit. She has litigated extensively before the Supreme Court of the United States, as well as numerous federal courts of appeals and state courts of last resort. She has twice argued before the D.C. Court of Appeals and also represented the United States in oral argument before the U.S. Court of Appeals for the Seventh Circuit. Professor Hawley continues to litigate, and her work has been widely quoted, including by the Washington Post and U.S. News. Erin's a graduate of Texas A&M. I don't know how you went from Missouri to Texas A&M, but I guess that's pretty cool because Cathy is from A&M and received her law degree from Yale Law School. So welcome, Erin Hawley.
For having me. It's really delightful to be here today, and I support fully the mission of constituting America. It is something I think we know way too little about, our Constitution and founding documents. I'm excited today that you are going to focus on the right to petition.
Yay. Okay. Well, do you want us, we know, look at your extensive, glorious, brilliant history here. Very impressive in everything that you've done and continue to do. And I know that you have been a part of petitioning. So why don't you give us a little overview about petitioning, and then we'll come in with questions.
That sounds great. So initially, as your listeners may or may not know, but there are generally regarded as being 5 protections in the First Amendment. And the text of the First Amendment, pretty straightforward. It provides that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. So in law school, they teach you to focus on words, especially when those words are in the Constitution. Here we have just read the First Amendment to the Constitution, and that amendment actually includes 5 various rights. Many of them work together, but they have separate components. And those rights, as you learned in your last podcast, include the right of religious liberty, freedom of religion. Also included are the freedom of speech, freedom of press, freedom of petition, and freedom of assembly. And it's really interesting, the museum here in Washington, D.C. Often will sort of poll citizens about different rights in the Constitution, different newsworthy items. And when they ask about the First Amendment, most people can identify freedom of religion and freedom of speech, but they said that only about 5% of the public could identify the right to petition as being included within the First Amendment. And as Janine mentioned, this right is extremely important to our government. I'm hoping that we can talk a little bit about its history. It has a long and venerable history, as long as any of the other rights included within the First Amendment's rights of freedom of religion and speech and press and petition. But it has some unique characteristics as well. And one thing I'm excited about is that the organization that I work with now, Independent Women's Forum, will often set up petitions in order to involve people directly in the process of government and to bring to the attention of different members of government issues that are important to we the people. So it is very much a tool, as Janine mentioned, and I'm very excited to talk to you in greater detail about this fabulous tool that's provided by our First Amendment.
All right, so do tell us about the history of petitioning. That would be fascinating to hear.
So absolutely. So the history of petitioning actually goes back all the way to the Magna Carta. And as we just read, the right in the Constitution protecting the freedom of petition says that the people shall have the right to petition the government for redress of grievances. And 3 of those important words, petition, redress, and grievances, all appear, interestingly, in the Magna Carta. And the Magna Carta, of course, was forced upon King John by nobles in his kingdom. And it was sort of a public acknowledgement that this document being forced on him, that nobles, at least a small slice of people in England, did have these rights that they could petition the king to redress. If they had a grievance, they could bring it before the king. And so this was sort of the genesis of the right to petition the government. Comes all the way back from the Magna Carta. And interestingly enough, I just love this. The Magna Carta is itself a petition. So it was a document sent to King John on a subject of government concern. And another key petition, especially in our country's history, is the Declaration of Independence. So of course, in 1776, the Declaration of Independence was issued. It was sent to King George, and it specifically cited King George's failure to provide redress for various grievances that had been sent to him by the colonies in petitions. So if you're reading the Declaration of Independence, it says that in every stage of these oppressions, we have petitioned for redress in the most humble terms. So in other words, the colonies had sent petitions to the King of England, but then they say in the Declaration, our repeated petitions have been answered only by repeated injury. So the petitions had not been listened to, had not been answered. And it continues, a prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people. So here we see in the very Declaration of Independence, this focus on the right of citizens to petition their governments to provide redress for grievances. Another interesting point of history, I just love history, and that all of the colonists would have been aware of in the 13 colonies was Blackstone's Commentaries. And Blackstone is sort of a legal commentary on the state of law in England. It existed at the time of the founding. And in those commentaries, William Blackstone writes that the right of petitioning, either the king in England or the House of Parliament, for the redress of grievances was a right appertaining to every individual. So here the colonies and the founders and the framers of our Constitution would have been very familiar with this right of petition that was included in Blackstone's Commentaries that traced its history all the way back to the Magna Carta. And they included that as a specific example and reason for separating from England.
Okay, I love history too, so I'm most intrigued by all of this. Okay, so I just want to make sure I understand three things well, and then I'm going to move on and let other people ask questions. First, let's start with the Blackstone Commentaries. Did he live during the Revolutionary era?
Yes, that's correct. Yeah, his commentaries were published during that time period.
Okay, so when in the Magna Carta was like around 1214 or something during King John. Right. Okay. So the Magna Carta, was that primarily though for the nobles, and that really wasn't for the common folk? And then I guess there was an evolution, and a few centuries later, by the 1700s, where they really believed that the petitioning was for the common folk as well. But the Magna Carta was really, they weren't really saying this was for the peasants. They were saying it was for the nobles. Is that true? I've always wondered.
That's exactly correct. So if you look at the Magna Carta, it did set out these 60-some rights that the nobles were requesting and sort of forced King John to accede to. But it really did protect a very small slice of English citizenry. It was for the nobles, and after the Magna Carta, they had the right to petition King John, at least a limited right. But then in the next 400 or 500 years, we see an expansion of that right to include every citizen, the right to go both to their king, which would have been completely revolutionary in the 1200s, and also the right to go to Parliament, which had become more important. So the right of every citizen of England to approach and to petition government, which was, as we've seen from the Declaration, really important to the founders.
And so they would have learned about that from the founders, because it was, I guess, before 1776.
That's correct.
Yes. Oh, well, hey, there you go. We're all learning. Last question before I toss it off, because I could just ask you a zillion questions. But you said that in the Magna Carta, were all five in there? Was religion in there, and petitioning, speech, press, and assembly? Or did you say that all five that are in our First Amendment were in the Magna Carta?
I am not sure about all five. With regards to the right to petition, all of the key words from our own First Amendment are actually in that document from the 1200s. It mentions the word petition, it mentions the word redress, and it mentions the word grievance, which really is just a fancy word for wrong. So I find it fascinating that this document from the 1200s carried forward those critical important words to our own First Amendment.
Okay. So see, I didn't catch that the first time. So it's not that all five elements in our First Amendment were in the Magna Carta, but the five or so words regarding petition are exactly the way they were in the Magna Carta.
Yes, that's
good.
Right.
Okay, I understand now. All right, who wants to go next? Tova, I'll let you go next.
Great, thank you, Janine. So, Erin, I know you've argued cases in front of the Supreme Court, but I'll say I'm also an experienced petitioner because when I was in second grade, the lunchroom was very messy, and I remember I ripped a piece of notebook paper from my notebook and ran around to all of the other second graders in the lunchroom and got them to sign it to argue that the lunch table should be clean. So I have plenty of experience petitioning, but it worked. But I love the right of petitioning and think it's great. So could you give, obviously at second grade, maybe I didn't develop the most effective petition. My handwriting wasn't so good, but what do you think are the most effective components of a petition that can actually get some traction? Like, what advice would you have, especially for young people, for developing a good petition for an issue that they're passionate about?
Right, that's a great question, Tova. And I actually think your lunchroom example is a really good one. And it's quite impressive that as a second grader, you are not only aware of your right to petition, teachers and school administrators, but put that into action and included other students in that plan of action. So I think just to take your example, one of the key things about having a successful petition is simply to identify something that you are passionate about. And something that others are passionate about. So if you want clean lunchroom tables, which seems like a good thing, and you know that others in your school also want clean lunchroom tables, then that could be a great thing to petition administrators on. So an issue that you're passionate about, a problem that you see that needs to be addressed, maybe the way an administrative agency functions or handles a particular issue that you think needs to be changed or fixed or corrected. So the first thing is just to find an issue that you care about and that you think will resonate with other people as well, as with the lunchroom. And then there's all sorts of ways that you can get this petition out there. The group I work with, Independent Women's Forum, they currently have a petition. It's called the Patients Protection Pledge. And I love this petition because it promotes price transparency in healthcare. And what that means is simply when you go to the doctor, you probably don't know how much you're going to pay for your service. And it depends on the type of insurance you have. It depends on how the provider codes certain things. And what this petition advocates for is simple price transparency. So when you go for a medical visit, that we as medical consumers should be able to know what it is that the service we're receiving will cost. And we should be able to know that up front. We all know when we go to buy a car or go to buy groceries, we know what the cost of that product is. And so with the Patient Protection Pledge, IWF has a petition that says that everyone has a right to know the price of healthcare services before receiving care, including cash prices and negotiated rates, all the different interplay between insurance and the providers of healthcare. And so then it sets up a pledge, and it says, I therefore pledge to support elected officials who will endorse and fight for legislation that delivers real price transparency, shoppability, and accountability. And so the second part of the pledge is sort of the idea that people signing it are committed to voting for and advocating for this price transparency. So it's nice to have sort of a concise statement of the issue that you're advocating for, and then also sort of an action item as to what it is that the people signing the pledge or petition are supporting. So that's just one example of something that you can do. I think IWF currently has over 50,000 signers on this particular pledge. So this petition has been doing well, but you can have petitions on all sorts of things. And one exciting thing about the petition clause now is that you can petition all of the branches of government. So it's been included to include courts, it's Congress, as well as the White House and executive offices.
That's great. And once you have like your petition filled out, how do you know like who would be the best person to send it to? And how do you just email it to them? Do you have to hand it to them? Like, how do you distribute your petition once it's ready?
That's a great question. I am not the best at the logistical details. IWF's communications team, your communications team would probably have great ideas on that. But a lot of organizations use various things like social media. So they will place sort of ads or posts sort of stating the issue on Facebook or Instagram or those sorts of things, and then invite students, invite citizens to participate in the pledge. One really neat avenue for starting a petition is actually one established by the White House. And it's called We the People. And it's this really amazing program whereby if you get 100,000 signers within 30 days, that's a lot of signatures. But if you do that within 30 days, then you're guaranteed a response. And it's really neat because every person who signs that petition will also receive a response. So you know that the agency or the branch of government to which it was addressed has considered that petition and then will respond to every one of your signers. So if you're going for something like that, you could encourage people to say, if we get this number, then you will receive an actual official communication from whatever agency or government office we are trying to influence.
Wow, that's great. Thank you for bringing that up. I don't know if I could get 100,000 signatures to clean my lunchroom, but if there's ever an issue I care about, I will definitely go through that avenue. And I was also wondering, does this amendment provide any guarantee, I guess other than that 100,000 mark, does it provide any guarantee that the government officials who you're petitioning have to respond? Like, can they just throw out the petition if they want to, or do they have to be responsive to you?
So that's a really good question. And in the 1980s, there was a Supreme Court case called Minnesota versus Knight. And the Supreme Court actually held that there's no requirement that the government listen or respond. And the court said that there's nothing in the First Amendment or in Supreme Court case law that required government to sort of respond to the different communications, different petitions from members of the public on public issues. So there's no requirement, according to Supreme Court precedent, that the government respond. And that probably comes back to the text of the First Amendment. If we look, it says you have the right to petition the government for a redress of grievances. It doesn't say, you have a right to an answer on a petition to the government. But interestingly enough, the government has at times tried to limit the right of petition itself. And that probably would be unconstitutional. So there's no right of response, but there is a clear right that you are allowed to petition the government.
Wow. And I guess if you're not getting a response, that's when your other First Amendment rights can come into play, right? If you have a really important petition and no one's responding, you can use the press, send that out to news media. You can hold a peaceful protest, use your freedom of speech to speak out on social media, stuff like that. So it's just genius how it all connects.
Absolutely. And that's a wonderful point, Tova. So I agree completely.
Yes, that's just what I was going to jump in and say. I was going to say, but the petitioning is just the beginning, and then you can use your speech in present. But Tova did it. Very good, Tova.
Well, Erin, I would love to hear a little bit more about how the government tried to limit the right to petition. One of our listeners had asked a question: do you believe every right has a remedy, and any right that is not enforceable is not a right? And so if the government was trying to limit the right to petition, obviously, I guess something came along and enforced eventually the right to petition. So I was just curious to know a little bit more about that.
So absolutely. So I think there's two questions contained within that. And the first one is sort of, or I guess let's take the second one first and deal specifically with one of your listeners' questions, is whether if there's no remedy, then does the right really exist, and what does that right mean? And I would argue that yes, there are rights that may not have a remedy. If we think of something that Congress writes a statute, we typically think that Congress has a responsibility of providing both rights and remedies. On the other hand, you can look back to one of sort of the foundational cases of judicial review. It's a case called Marbury versus Madison, decided by the early court under Chief Justice John Marshall. And in Marbury versus Madison, the principle of judicial review, which is the idea that courts can strike down statutes or strike down executive actions as being contrary to the Constitution, wasn't a foregone conclusion. So the court was kind of feeling its way as to what its role would look like in the American government under the Constitution. And so Chief Justice Marshall sort of says that, we have a Constitution that's written. It's written for a reason. And the reason is that the Constitution is supposed to be the supreme law of the land. And if we have a congressional statute that violates the Constitution, then we as the judiciary have to declare that statute invalid. So Marbury versus Madison was key in establishing judicial review. But it also said that where there's a legal right, there has to be a remedy, that the law has to provide a remedy. So that's sort of one school of thought. However, if you look at the Petition Clause, the words of the Petition Clause sort of guarantee a procedure. So it uses the words, the right to petition the government for redress of grievances. So it's this sort of procedural right, rather than the First Amendment saying you have a right to a remedy should the government sort of cause a grievance. And where this really comes to matter, sort of we're getting into the weeds here, but we know that one form of petition is the ability to file a lawsuit against the government in the court system. And when you file this lawsuit, there are all sorts of things that might mean your lawsuit can't go forward. You might be outside the statute of limitations. You might not have exhausted your state court remedies. You might not have exhausted administrative remedies. All these sorts of things that can kind of come in between you and the remedy that you're seeking. And so if we're talking about a court filing, traditionally, the Supreme Court has viewed it as the right to file the lawsuit rather than the right to receive a remedy on the substance of that lawsuit, if that makes sense.
Definitely. And we also, one of our sponsor actually, Mr. Zimmerman, Robert Zimmerman asked, the Supreme Court can strike down executive privilege of the president. He's asking that, can the Supreme Court strike down executive privilege of the president? And can you give an example of when this last happened?
So no, I don't think that the Supreme Court can strike down executive privilege. So there's a whole sort of body of law that goes to what is sort of executive privilege. There's certain things that might be privileged in civil litigation, certain things that might be privileged in criminal litigation, and the court sort of works out, how far that privilege extends. What the Supreme Court can do is they can strike down executive action. Sort of routine examples of that is when the Supreme Court would strike down an administrative rule. So maybe it's under the Clean Air Act or the Clean Water Act, and the Environmental Protection Agency has promulgated some sort of rule under the executive branch, and the Supreme Court might strike that rule down as unconstitutional. There's also the more dramatic examples, like the case of Youngstown Steel, where the president had taken over operations of a steel operating plant, sort of for national security. And the Supreme Court said that the president couldn't do that, consistent with the Constitution.
Right. And finally, just a cute story, and then I'll turn it back to Janine. Father Michael Bishop, who's one of our regular listeners, says, Tova reminded me of my experience in the seminary. I had a complaint about the food, and I verbally started a petition that was presented to the student council, and we got results. Even the dean of students agreed with my complaint. So there you go. It's lots of
Powerful stuff. Okay, I'm going to go to Dakare next, but I do have a quick question about executive privilege, just so for clarification. When Mr. Zimmerman asked about executive privilege, is that the same thing as an executive order? And I think it would be really interesting to talk about executive orders because it is, to the best of my knowledge, and my Constitution is somewhere. It's usually right here, but it's not right now. I believe that executive orders are mentioned in the Constitution, and George Washington did like 3 of them or something. So what's the difference between an executive order and executive privilege? And it is listed in the Constitution, is it not?
So Article 2 of the Constitution lays out the president's authority. Article 1 talks all about Congress. Article 2 talks all about the executive, and then Article 3, the judiciary. And so Article 2 gives to the president broad executive authority really to determine in his or her discretion how to enforce the law and manage the executive branch. So the Constitution assigns to the president the role of commander-in-chief and also the chief law enforcement officer. So it's sort of out of this ability to issue an executive directive that we get the executive order. So the executive orders aren't mentioned in so many words, but they sort of come from the powers that are granted to the president under Article 2. And executive orders are issued by the president, him or herself, and they sort of lay out that lay out an agenda or a policy agenda for the executive. So that is a little bit different. Executive privilege is something that is accorded to the president sort of by virtue of his office. So the big time that executive privilege comes up is when the president is sued in court. This happened during the Clinton administration, it happened during the Nixon administration, and the courts have to sort of sort out how much courts are allowed to interfere with the day-to-day workings of the executive. The president obviously has a really important job, so there's some level of executive privilege and protection that applies to his or her work. So you've got executive privilege, which sort of deals with protecting the president's sphere of authority. We've got executive orders, which are his or her executive directives. So those are a little bit distinct.
Great. I just didn't know when he was asking that question exactly what he meant. I think it may be a good example of executive privilege will be when they say, it's my executive privilege to have a conversation with my chief of staff, and my letters back and forth to him are under executive privilege. I think that's one good example. But it does say here, Article 2, Section 1, Clause 1 of the Constitution simply states, quote, the executive power shall be vested in the President of the United States of America. So that's what you're talking about. That's the broad clause, right? Yeah. Yes. Okay, Dakare, your turn.
I'd like to ask you how many signatures you need for the Supreme Court to read like your petition.
So that's a good question. And petitions work a little bit differently in the court branch than they do in the government branches. So if you send a petition to your representative in Congress or in the United States Senate, then there's a process by which that congressman or woman can send your petition to the clerk, and it will be entered on the record. So that's a way you can get your petition before those houses of government. With the White House, again, they have the We the People sort of platform, which guarantees a response if you get 100,000 signatures within 30 days. With courts, the courts are actually not a real natural fit between the Petition Clause. Originally, the Petition Clause extended in the sort of historical framework as a right to petition Parliament or the King. The courts weren't mentioned. As American law has developed, they have included, the Supreme Court precedent has included the right to file a lawsuit. But a lawsuit sort of matriculates up the stream. So you would first file with the district court, then with the Court of Appeals, and then with the Supreme Court. And no court is going to look at a petition that just says, like the Patient Protection Pledge for Independent Women's Forum. A court wouldn't look at that, but you do have the right to file a lawsuit. And if the lawsuit works its way up the chain, then there's not a particular number of signatories or those sorts of things. So the petition process looks a little different in courts of law. You have to file sort of an actual lawsuit and follow the legal procedures for that. But good question, because they look a little different.
Thank you. Another question. So as far as I know that website you showed us looked more like a pledge. What is the like specific verbiage, and do you have to have it on a website, or can it be like mailed, or
So you can do any of the above. So websites are very easy to collect. So it's an easy way to get signatures. We the People, the White House's website, recommends that sort of thing, just because it's easy to send or post a link, and people can easily access it. And there's not specific requirements really on the types of language. The key thing is that you're seeking some sort of action from the government. And this also has expanded under Supreme Court precedent. The early interpretations of a petition were simply to sort of stop the government from doing something bad, or to have them sort of rectify a prior wrong, or to correct something. But now petition is much broader. It includes situations like Tova mentioned, where you're asking the government to make affirmative changes to improve your lunchroom. So affirmative changes that would help aid in American life. So not only to remedy past wrongs, but also to change the way government operates. So it's a broader right than it was historically thought of. But there's no specific language. That the key is that you're asking the government to either correct something or to do something differently.
I didn't catch how many. I know you need 100,000 for the We the People in the White House. How many signatures do you think you really need to make an impact in the legislative branch?
That's a good question. And I would ask you the same question for your advocacy work. I think we're very pleased to get 50,000 signatures for the Patient Protection Pledge. That seems like a lot of people who are interested in this issue of price transparency. So that's one of the ballparks that we aim for. Included among those signatories are various representatives and congressmen and senators and those sorts of things. So that's always helpful as well, if you can get sort of representatives of people or members of other organizations that can help spread your word.
So I know that when I'm doing like resolutions for, Model United Nations, signatories are just people who just want to hear this presented. They're not saying that they want this to happen. Like, are there sponsors and signatories?
So I don't think that those words are used in that specific context, like they would be for the United Nations. People who sign, the signatories, are people who are supporting the petition. So you would need, again, to go back to the White House example, you'd need 100,000 signatories to be guaranteed a response. Gotcha. I guess the sponsor in this sort of example would be the organization like Independent Women's Forum who is promoting the petition.
So does this right to petition only apply to citizens of the United States, or can anybody sign or create a petition in the US?
So if you look at the text of the First Amendment, it says of the people. So that would presumably apply to anyone, certainly who is a citizen, but also I think that it would apply more broadly. I could double check on that one for you.
This is something I just sort of thought of while we were sitting here, but I thought it's kind of interesting. It reminded me that when in a lot of states, and I know at least in Virginia, we have to get a certain number of signatures on a petition for a candidate to get on the ballot. And I thought that's just an interesting use of petitions that is actually, I guess that's parties may make that. I'm not sure it's codified into any state law, but do you know any other examples where states or governmental bodies actually use the petition as in sort of their lawmaking?
That's a good question. I don't know of any examples where they use the petition in lawmaking, aside from certain legislators, for example, when they're talking about different various proposals, can mention petitions as something that has been brought to their attention. If we go way back, one of the, I think, neatest examples of the use of the petition clause was the abolitionist movement in the 1830s. So Congress, the House of Representatives in particular, was really overwhelmed by these petitions to end slavery. And they actually instituted a gag rule. And this House procedural rule said that any petition advocating for abolition, any anti-slavery petition, would be automatically tabled. So it wouldn't be considered, wouldn't be put in the record or the floor. And John Quincy Adams was absolutely appalled. He said this is very contrary to the First Amendment. He gave a speech on the floor where he said, am I gagged or am I not? And a few years later, the House rescinded a rule that seems pretty obviously unconstitutional. So you do see sort of that example of John Quincy Adams relying on petitions to say this is an issue we need to address.
Interesting.
So I guess that would be one of the examples when the government has actually tried to stop petitioning, because you had mentioned that earlier.
Yes, that's correct. So during World War I, for example, there was actually criminal penalties for petitions that advocated for sort of striking down the Alien and Sedition laws and those sorts of things. Again, I'd suspect that those sorts of bans on petitions would be unconstitutional under the First Amendment. That doesn't mean that the government needs to act or that the petitions were merit-worthy, but certainly the First Amendment provides the right to petition the government about matters of public concern, of which war would certainly be one.
That's because people wanted peace. They didn't want to enter into World War I, but what Wilson wanted wanted to enter into World War I, so he shut down the petitioning. Isn't that what happened?
Yes, that's correct.
Yeah, but that didn't stand in the court. Was that ever? Did anybody ever take that on to say that wasn't constitutional?
I don't think that it was litigated. From my perspective, it's plainly a good case under the Petition Clause, but I don't know that it was litigated.
I'm sorry, you lost me with lawyer lingo. What do you mean it was a good case? I don't understand. So if, let me make sure I have this clear. I'm just an actress. Okay, so if you have a right to petition, but Woodrow Wilson tried to shut people down for petitioning because they wanted peace and didn't want to enter the war, are you saying that Wilson had the right to shut that down?
No, I would say someone challenging that action of shutting down petitioning would have a good argument under the Petition Clause that they should be allowed to present that petition.
Okay, good.
People petitioning had a good case.
Okay.
I just want to thank Erin for being here today, Erin, and this, Janine, this was a great topic. And I think, as Erin said in the beginning, only 5% of Americans, I think you said, can name the right to petition as one of the rights embodied in the First Amendment. And so, and this was Janine's idea to focus on the petition because she teaches that so often when we go into the schools. And so I just want to thank you. And this is a great program. I learned a lot. Thank you.
Well, since we have 2 more minutes, what I will talk about is and maybe you can touch on this a little bit since we have 2 more minutes here. What we do when we give our Socratic presentations and interchanges with the students, when I'm doing this, I focus on the fact of exactly what Tova said earlier, because she's heard it so many times, that the petitioning is just the beginning. And it's like you said, you can get 100,000 signatures, but the government doesn't really have to do anything. They say, okay, we acknowledge it, but they don't have to do anything. So it really is important then. What I believe is that the petition is the first tool in the toolbox of the First Amendment. You get your thoughts organized, you know exactly what you want to do. Then that's just the beginning, the structure. You bring in the speech and you bring in the press, and then you plan your assembly, and then everyone has a copy of the petition and they're very educated at the assembly. Then you call your representative. So it's sort of a stair step to actually accomplishing and working the government to affect change. If you want to give us some closing thoughts on that.
Absolutely. I think that the rights of the First Amendment all do exactly, she said, work together So that the whole point of democratic government, of Republican form of government, is that we, the people, are able to influence the laws that are enacted. We're able to influence and vote and hold accountable our elected representatives. And one way, a great way to do that is simply through the First Amendment. If you start with the petition, then you can organize, you can peaceably assemble, which is a really important right. In today's society, we see different restrictions from the coronavirus and safety restrictions, and that sort of brings up, the right to peaceably assemble. What does that look like in pandemic times? And what are these First Amendment rights that we need to be aware of and to protect? You have the right to speak freely, which is so important to our society for the free exchange of ideas. And I would just encourage all of your listeners that it's the First Amendment, and it's one of our fundamental rights as Americans, is to be able to exercise this right for the betterment of ourselves and our government, to be able to bring these issues to their attention.
And we should maybe all check out the Blackstone Commentaries, because that sounds pretty interesting. Maybe we'll do a series on that. Okay, yes, you have been so amazing, Professor Erin Hawley. Thank you so much for today. I hope all of you enjoyed listening as well. It was most educational, and you're just simply brilliant. And thank you for your time so much today.
Thank you.